Assalamualaikum warahmatullahi wabarakatuh and very good morning to Madam Shahila and my fellow friends. My name is Najwa binti Rosli with my group mates Fatin, Aminuddin, Khairunisa and Wazifa will present our slides today. As you can see on the screen, our topic today is vicarious liability. I will begin by explaining the introduction of vicarious liability. Vicarious liability is a situation in which one party is held partly responsible for the unlawful actions of a third party. The third party also carries his or her own share of the liability. Vicarious liability can arise in situations where one party is supposed to be responsible for a third party and is negligent in carrying out that responsibility and exercising that control. For an example, an employer can be held liable for the unlawful actions of an employee, such as harassment or discrimination in the workplace. Every person is liable for acts commits and not liable for the acts done by others, but in some situations, when a person is liable for the acts of another person is known as vicarious liability. So, for this to happen, there must be a specific kind of relationship between both the people, and the act must be connected with the relationship. Vicarious liability only deals with the situation where the person is liable for some other person's act. It is considered as an exception to the general rule that the person liable for his or her acts only. Okay, next, I will go on to the topic requirement of vicarious liability. Firstly, liability of the principal for the act of his agent. When a person has got the authority to perform a certain act, but he authorizes it to someone else working under him, this relationship is known as a principal-agent relationship. When the principal authorizes an agent to perform some tertiary act, the liability for that will be not only of that person who has committed it, but also of that has authorized it. Next, liability for the tort of his servant. This relationship of master and servant is also the same as that of principal and agent, where for every wrongful act of the agent, the principal is liable, like for the wrongful act of the servant, the master is to held liable. Therefore, for every wrongful act of the servant, the master is presumed to have done that by himself. Lastly, liability of partners of each other's wrong. The wrongs done by one partner under tort law will result in making the other partner also liable in the same manner as the principal is held liable for the wrong act of his agent. The rules of law agency apply in cases of their liability also. Therefore, for the wrongful act of one partner of a business firm, the all other partners are held liable to the same extent as that of the guilty partner.
The importance of vicarious liability is to increase ability of the company to perform key business functions and potential losses, at the same time ensuring the rights of both parties involved are guaranteed under this law. There is three reasons why vicarious liability must to be imposed, which are protect the employees, liability of the employer, and also rights of third party. Firstly, protect the employees. The employer poses a risk of harm to third parties due to the negligence of its employees. Thus, with vicarious liability, the employer must also accept all risks borne by the employee. Secondly, liability of employer. In common situation, when an accident happens, the employees alone unable to bear the loss of damage. Thus, the employer should take responsibility of the issue. Last but not least, rights of third party, whereby to ensure the rights of third parties are guaranteed from loss, A third party can claim the damages due to the accident done by the employees of the company.
Example of vicarious liability. As you know, at 24 May 2021, around 8:30 p.m., there was a massive accident involving 213 passengers of LRT from Gombak which collided with an empty train that was coming from the Kampung Baru LRT station. 47 people suffered serious injuries, while 166 others escaped with minor injuries. The empty train's driver said he was being test driven because it was previously found to have experienced a problem. On initial investigations, there is a possibility of miscommunication at the control center which could have led to the accident. As you can see, the prasarana offers RM1000 in compensation to all crash victims that will also cover medical costs and lost income. Logically, the accident involved the passengers and the LRT drivers only. But in vicarious liability law, the employer or prasarana involved to pay the compensation to the victims because the employer creates the risk of harm to the third party by hiring the employees.
Assalamualaikum and good morning to Madam Shahila. My name is Vicarious bint Farul Azman. Today for my part, I will talk about the test and related cases to vicarious liability. The purpose of vicarious liability is to obtain a just and practical remedy for the victim so far as possible and to deter future harm. To fulfill this purpose, there are three tests that were developed to check the existence of the employee and employer relationship. These are the three tests. The first one is control test. It is the first significant test that was developed by the court. Based on the test, a person is said to be an employee if his employer retains a right of control not only the work he does but also how he does it. In other words, the employer is the party that states the work policy of the employee and in charge of the employee when he is carrying out his duties as an employee. Next is the integration test. In this test, the court will play an important role by analyzing whether the work performed is integral part of the business operations of the person hiring the employee or merely complements it. Lastly, the multiple test. This test is more depends on where it considers several factors to determine whether there are relationship between employee and employer. Factors such as remuneration by payment of wages or salary, holiday pay, or payment when absent illness. The first case is Buzzley versus Curry. Foundation made an argument that as a non-profit, it should not be found vicariously liable. It is unfair to fix liability without fault on non-profit organization performing needed services on behalf of the community as a whole. The judge dismissed the argument as crass and unsubstantiated utilitarianism. The appeal was dismissed and the matter was sent back to trial to determine cause. Next is Yuan versus Noakes. The core issue of the case is regarding the payment of inhabited house duty. Therefore, the key question was whether the claim is a servant of the defendant. It was held in this instance the claim did not fall under the definition of a servant. On appeal, the court held that the premises were purely for trading purposes. Thus, the claim was only a caretaker. Lord Bramwell stated that a servant is a person who subjects to the command of his master as to how he shall do his work. Lastly, for case Lister versus Hasley Halls Limited. The House of Lords held that the vicarious liability can arise for unauthorized intentional wrongdoings committed by an employee acting for his own benefit. insofar as there exists a connection between the wrongdoings and the work for which he was employed to render it within the scope of employment. So, the court rejected the restrictive view that vicarious liability could only arise when the employee is acting for his employer's benefit.
Assalamualaikum warahmatullahi wabarakatuh, and a very good day. Hi, Wazifah here. I'm going to continue with the supporting document and conclusion. So here are several news that I'm going to show you, which is upon the death case of a police officer that has been advised by the lawyer to sue corps governments for the negligence. Next is the supporting documents on the news about a Hindu mother that sues IGP police over failure to return her daughter being kidnapped by her ex-husband. So, other than that, we also have this news upon a security firm loses appeal over liability in shooting. And also, news about a foreigner claim for negligence against the government for injuries sustained upon him after hitting a pothole by his motorcycle. So all of these news are regarding the vicarious liability. So in conclusion, how fair is vicarious liability? As we know, vicarious liability seeks to ensure that, when appropriate, the employee is held liable for the torts of their employees. Although some of the rulings in the preceding cases appear to be severe on the employer, the law is still fair in general. We only see the bad side of the employer because of them severely enduring the effect of the vicarious liability applied on them. However, the vicarious liability is fairly to be taken to both parties for the cases to be settled down. In my opinion, we can look back to the case on the news that happened to a police officer that brings him into debt, but being neglected by the police or cops, governments also. So since it's really good for the vicarious liability to be applied on that case. When considering vicarious liability situations, the court might consider a wide range of topics, legal terms, and perspectives. Still, we need to follow the procedures of the legal terms, also need to explore more of the range of the topics to make these cases being settled down fairly. Many times, it appears to be utterly unreasonable for an employer to be held accountable for an employee's improper behavior. The employer, on the other hand, may be held vicariously accountable. So, vicarious liability is giving benefits as well to both parties as to ensure the right of both parties are guaranteed under this law, and also to increase the ability to perform key business functions and potential losers, for example. Okay. Last but not least, overall, when an employee's duty of care is breached, but the claimant is unable to determine which employer did so, vicarious liability might be proved. An employee will not be exempt from accountability if a specific employee cannot be identified as the perpetrator of the breach. So, vicarious liability also helps in finding out the proof of the claimants of the employee. So, the vicarious liability can be said to be made fair in general. That's all from me. Thank you for listening.